Oh, hello. Welcome to my bar review show. Today we're talking about partnerships. Partnerships involve formation, relationships, and termination, limited liability partnerships, and liability partnerships. The relationships will include the partner with partnership and between partnerships, and between partners, and the relationship with third parties. Termination will also include merger and conversion. Formation includes partnership requirements, partner by estoppel, partnership's nature. Partnership requirement, intent. Two or more persons or entities must intend to carry on for-profit business as co-owners, but do not need specific intent to form a partnership. So for-profit, but they don't need to intend to form a partnership. Partnership agreement, to conduct for-profit business as co-owners, can be implied by conduct in written or oral agreements absence. Statute of frauds. Written agreement is not required for formation, but contract that cannot be performed in 1 year must be in writing per statute of frauds. Extensive activity. Court will consider amount of related activities directed toward achieving business's end goal when determining whether partnership exists. Profit sharing test. The rule: if profit sharing exists, entity is presumed partnership. Exceptions. Sharing profit does not create a presumption of partnership in 6 statutorily enumerated circumstances. Debt payments, interest loan charges, rent, wages, goodwill payments from business sale, and annuities of other retirement or health benefits. All right, we're moving on to partner by estoppel. Cases. Partnership does not exist, but person is treated as purported partnership's partner. The other case is partnership exists, and person who is not a partner is treated as a partnership partner. Elements. Person may be treated as purported partner if there is rep, oral, written, or conduct implied. Person is partner in partnership. Person makes or consents to rep. Third party reasonably relied on rep, and third party suffered damages as that reliance's result. Liability. If partnership is liable, purported partner is liable as if she were partner. If partnership is not liable, purported partner is jointly and severally liable with those who consented to the rep. There's no duty to deny rep. No duty to deny rep. Merely being named by another is not enough to create liability. It is not a defense. Purported partner was unaware he had been held out as partner to specific third party if rep was made in a public manner. Purported partners are person making rep's agent. Partnership's nature. Separate legal entity. Partnership may hold property and can sue and be sued. Partners are not protected from personal liability for partnership's obligations. If formal partnership agreement exists, it generally governs when conflict between partnership agreement and RUPA exists. Time for a break. All right. Now we're on to relationships. And this is going to be the relationship specifically of partner with partnership and the relationship between partners. These include partner as agent to partnership, fiduciary duties, profits and losses, partner's account, distributions, partnership interest, property ownership, new partner, management rights, remuneration, reimbursement and indemnification, use of partnership property, access to records, lawsuits, disassociation, and in disassociation we'll specifically talk about events causing disassociation, wrongful disassociation, effective disassociation. That was a long list, so buckle up. We're about to get into it. All right. We're talking partner as agent to partnership. Partner can commit partnership to binding contracts with third parties. All right. Fiduciary duties, loyalty duty, the rule. No competing with partnership business, advancing interest adverse to partnership, or usurping partnership opportunity. An exception. Partnership agreement can designate certain activities as not violating the duty, but cannot eliminate the duty altogether, and may provide safe harbor, allowing other partners to authorize or ratify transaction between partner and partnership after full material facts are disclosed. Care duty, a duty to refrain from engaging in grossly negligent or reckless conduct, intentional conduct, or knowing law violation. Partnership agreement may not unreasonably reduce this duty. Disassociation or dissolution. On partners' disassociation or partnership's dissolution, duties do not apply unless partner is engaged in winding up partnership's business. Good faith and fair dealing. Partnership agreement cannot eliminate this obligation, but can prescribe reasonable standards. All right. Profits and losses. If no partnership agreement exists or partnership agreement is silent, each partner is entitled to equal profits and losses share. If partnership agreement only specifies profits division, then losses are shared in the same manner as profits. Partner's account contains partners' contributions to partnership and partners' profit share, less distribution, losses, and liabilities. Distributions. Partner cannot demand profit distribution, but is entitled to have her account credited with her profit share. Partnership interest. Personal property interest, consisting of right to share in partnership's profits and losses and to receive distributions. Transfer to a third party. Rule. Partner can transfer all or part of partnership interest, absent restriction in partnership agreement. Transfer or partners retain all rights and duties of a partner, except for interest in distributions. Transfer does not cause dissolution or disassociation. Continuing. Transferee's rights. Right to receive distributions. Got it. Gets the money. Seek a judicial order for dissolution. Got it. And accounting on dissolution. Got it. No right to participate in management or conduct of partnership business. All right, so you're not involved in the power. Access to P's records, can't get at the records, or demand other info. Property ownership. Rule. All property partnership acquires belongs to the partnership, not individual partners. Property may be acquired and titled in partnership's name or in name of one or more partners who indicate their capacity as partners or partnership's existence. Partner's intent controls. Partner's intent controls property, presumed partnership's property if property is presumed partnership's property if purchased with partnership assets or if partnership credit used to get financing. But if ownership is unclear, consider other factors such as property's use, property's tax treatment, and source of funds to maintain and improve property. A new partner. Incoming partner must secure all existing partners' consent. Management rights. Each partner has equal management rights and actual authority to conduct usual and customary partnership matters, unless reason to consult other partners exists. Majority of partners need to make ordinary partnership business decisions. All partners' consent is required for matters outside ordinary course of partnership's business and for all partnership agreement amendments. Remuneration. Remuneration. None except for reasonable compensation for winding up P's business, partnership business. Reimbursement and indemnification. Partnership must reimburse partner for loans made in furtherance of partnership business, and partnership is required to indemnify partners for personal liability incurred in ordinary course of partnership business. Use of partnership property. Partner cannot derive personal benefit from partnership property's use or possession. Partner must compensate partnership for such use or possession. Access to records. Partnership must permit its partners and agents to access all partnership records. Lawsuits. Partnership may sue partner for partnership agreement breach or violating duty owed partnership. Partner may sue partner or other partner to enforce partner's rights under partnership agreement RUPA. Disassociation. Events causing disassociation. Partner's withdrawal notice, partner's expulsion because of partnership agreement, unanimous vote of other partners, or partner's bankruptcy. Partner's death, guardian appointment for partner or judicial determination of partner's incapacity to perform his partnership agreement duties. And finally, entity partner's termination. Wrongful disassociation. Unlimited by time or undertaking. Partner's disassociation wrongful only when it is express partnership agreement provisions breach. Partnership for a definite term or undertaking. Partner's disassociation is wrongful if before term's expiration or undertaking's completion, partner withdraws, is expelled by court order, is bankruptcy debtor, or is not individual trust or estate, and partner is willfully dissolved or terminated. Disassociation's effect. Disassociated partner is not permitted to participate in the management or conduct of partnership business. Partner's duty not to compete ends on disassociation. Partner's loyalty and care duties terminate with respect to post-dissociation events. Ongoing partnership must buy out disassociated partners' partnership interest. Indemnification. Partnership must indemnify disassociated partner against all partnership liabilities, whether incurred before or after disassociation. Disassociated partner's liability. Disassociated partner generally is liable for partnership obligations incurred before disassociation. Post-dissociation action. Disassociated partner can bind himself in partnership to transaction if other party reasonably believes disassociated partner is partner, does not have disassociation notice, and is not deemed to have knowledge of disassociated partner's authority lack. All right, now we're talking about relationships. We made it through that one, the first part of relationships. Now we're going to talk about the second part of relationships. These are relationships of the partnership with third parties. They include the power to bind the partnership, effect of partners' tortious acts, and liability to third parties. Partner as partner's power to bind partnership. Partner as partnership's agent. Partner can contractually bind partnership when partner acts with actual or apparent authority. Actual authority includes express and implied authority. Actual authority includes both express and implied authority. Express authority can arise from partnership agreement, partner's authorization, or authority statement filed with state. Implied authority, based on partner's reasonable belief, action is necessary to carry out his express authority. Apparent authority, partner must perform unauthorized act in ordinary course of partnership business. Third party with whom partner was dealing cannot hold partnership liable if third party knew or was notified partner lacked authority. So frustrating. Transfer of title partnership property. At times, partner has authority to transfer title partnership property. Transfer of title partnership property. Well, partnership property held in partnership's name. Partner has authority to execute transfer instrument in partnership's name. Transfer of title partnership property held in partner's name. Partnership property held in partner's name. So before it was in partnership's name, now it's in partner's name. Partner has authority to execute transfer instrument in one or more partners' names. Recovery of partnership property from transferee is recoverable. Recovery of partnership property from transferee is recoverable if partnership interest was indicated in transfer instrument through which partner acquired property, or if transferee was aware property belonged to partnership and partner executed transfer without authority. Recovery of partnership property from transferee is recoverable if partnership interest was indicated in transfer instrument through which partner acquired property, or if transferee was aware property belonged to partnership and partner executed transfer without authority. Partnership's knowledge and notice. Absent fraud, partners' knowledge or notice of a fact relating to partnership is generally immediately imputed to partnership. Person who owns all partners' interest in partnership effectively has title to all of partnership property and has power to transfer title to himself. All right, statements of partnership authority and denial. To clarify existence and scope of partner's authority, statements of partnership authority and denial may be filed with state. Effect of partners' tortious acts. Partnership is liable for partners' tortious acts committed in ordinary course of partnership business or with partnership authority. Liability to third parties. Partnership's obligations. Partnership is subject to suit for its obligation. Partners are jointly and severally liable for all partnership obligations. Judgment's effect. Judgment against partnership is first satisfied from partnership's assets and partner's personal assets. Criminal liability. Partner can be convicted of a crime and penalty is leveled on partnership assets. Time for a break. All right, we made it through relationships. That was super long. Now, let's talk about termination and change. And this includes conversion, merger, and termination. So we have conversion and merger, then we have straight up termination of partnership. Conversion, partnership to a limited partnership. Conversion must be approved by all partnership partners, and partnership must file conversion articles with state. Former general partners remain liable for pre-conversion obligations. Limited partnership to a partnership. Conversion must be approved by all general and limited partners, and limited partnership must cancel its limited partnership certificate. Partners remain liable as limited partners for pre-conversion limited partnership obligations, and are liable as general partners for post-conversion partnership obligations. Effect on partnership. Conversion has no effect on partnership as entity. Partnership-owned property remains partnership-owned. Legal proceedings by or against partnership continue as if conversion had not occurred. Merger plan. Merger plan must set forth names of original and surviving entities, entity type surviving entity will be, merger's terms and conditions, manner of converting merging entities' interest and obligations into surviving entities' interest and obligations, and surviving entities' address. Approval. All general partners must approve, as required by law or as specified in partnership agreement for limited partnerships. Effect. All parties other than surviving entities cease to exist. All property and obligations of original entities become that of surviving entity. Termination of partnership. Events causing dissolution. Partnership at will, an open-ended partnership with no fixed termination, is dissolved when disassociating partner gives withdrawal notice. Partnership for a term or an undertaking. Dissolved when term expires or undertaking is complete, all partners agree to dissolve partnership, or partner is disassociated due to death, bankruptcy, or other event. At least half of remaining partners agree to dissolve partnership and at least half of all remaining partners agree to dissolve partnership within 90 days. Any partnership dissolved on occurrence of event agreed to in partnership. Event that makes it unlawful for partnership business to be continued, or judicial determination. Winding up. Person winding up partnership business may dispose of and transfer partnership property, discharge partnership's liabilities, and distribute partnership's asset to settle partner's account. After dissolution, partnership is bound by Partners Act appropriate for Partners Act appropriate for winding up, as well as any partner act that would have bound partnership before dissolution if other party does not have dissolution notice. If other party does not have dissolution notice, each partner is liable to other partners for his partnership liability share. Creditors have priority over partners to partnership assets. Partnership's continuation after dissolution. Before winding up is complete, partner may resume carrying on its business as if dissolution had never occurred. Time for a break. You can pause the video and come back when you like. Okay, we're back. Now we're going to talk about a limited liability partnership. LLP partner, a limited liability partner, is not personally liable for limited liability partnership obligations. Limited liability partnership partner is not personally liable for limited liability partnership obligation. He is only personally liable for his own misconduct. States limited liability partnership status qualification revocation has same effect as cancellation. Time for another break. You can pause the video and come back when you like. All right, let's talk about limited partnerships. These include the rule, limited partner, general partner, contributions, profits and losses, distributions, assignment of partnership interest, termination, derivative action. The rule must be formed by at least one general partner. Limited partnership. Limited partnership must be formed by at least one general partner and one limited partner. Limited partner's liability for partnership's debts is limited to her capital contribution to partnership. Limited partnership is not formed if certificate of limited partnership is not filed. Limited partner can only be admitted by all partners' written consent after creation. A limited partner has right to vote as permitted under partnership agreement and right to inspect business and financial records. Can lend money and transact business like non-partner with limited partnership. Is generally not personally liable for limited partnership obligations unless limited partner is also general partner or participates in control of business. General partner, the rule, can only be admitted by all partners' written consent after creation, has rights and powers of partner in partnership without limited partners, may contribute to limited partnership, may contribute to limited partnership, share in its losses and profits, and receive distributions. Liability to third parties, personally liable to third parties for limited partnerships obligations. Can withdraw from limited partnership by giving other partners written notice. Other events may cause general partners termination. Contributions. Partners can contribute cash, property, or services and are obligated to limited partnership with respect to any written enforceable promise of whatever that is. Something contribution. Profits and losses may be allocated on any basis if in writing, otherwise based on each partner's partnership contributions. Distributions may be allocated on any basis if in writing, otherwise based on each partner's partnership contributions. Assignment of partnership interest. Partnership interest in limited partnership is personal property that can be assigned in whole or in part. Assignee generally has rights only to receive distribution to which assignor partner would otherwise be entitled. Termination occurs after dissolution and winding up. Partnership dissolved. Partnership dissolved on specified events occurrence. Written consent of all general partners and limited partners owning a majority of distribution rights. General partners withdrawal or judicial determination. Winding up. General partners wind up, but if none, their limited partners may. Asset distribution, first to creditors, then the partners. Limited partnership derivative action. Limited partner has right to bring derivative action on limited partnership's behalf. And we're done.